43503, the State of Ohio versus Johnny Brewer. Mr. Brewer is before the court with his counsel, Mr. David Brewer. Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson, what are we doing?
Your Honor, it's my understanding that the defendant will be entering a guilty plea as charged in the indictment, which is one count of theft, a felony of the 5th degree. There is no agreement on sentence.
Mr. Brewer, is that accurate?
Yes, sir, Your Honor.
Okay, Mr. Johnny Brewer, they're telling me that you're going to be changing your plea to guilty to the one count from the indictment. Before we get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
I'm 51, sir.
How far did you go in school?
I graduated and went to college for 2 years.
Are you able to read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this matter?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Brewer?
Absolutely.
And the two of you are not related, correct?
No, sir.
All right. Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Do you take medications that interfere with your ability to understand what's going on?
No, sir.
Okay. I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
Yes, sir.
Do you feel like you understand what it says?
Yes, sir.
All right. This document says you're entering a plea of guilty to theft, a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalty?
Yes, sir.
Now, you are also subject on this charge to a discretionary period of post-release control, which means that when you are released on this charge, upon your release, the Adult Parole Authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the Adult Parole Authority can return you to prison for up to 1/2 of the court's original sentence. If your violation is that you've committed another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
Now, at that trial, you would have a right to see and hear all the evidence that the prosecutor has against you. With the help of Mr. Brewer, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's called your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
Now, the burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt, and that standard applies to each of what are called the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
All right.
And you understand that a plea of guilty is a complete admission of your guilt, and the court could and will proceed directly with judgment and sentence.
Yes, sir.
Is this how you want to proceed today?
Yes, sir.
All right. Ms. Tranter, I'm sorry, Ms. Nicholson?
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 5th of 2025 in Turtle Creek Township, Warren County, Ohio, the defendant took belongings from the victim's vehicle without the victim's consent. Those included an iPad and 2 swords that had been gifted to the victim. It was later, there were surveillance footage from the trailer park showing the defendant riding his bicycle through the park with the sword strapped to his back. It was also confirmed by witnesses that he traded the iPad for dinner at a restaurant.
Mr. Brewer, anything on those facts?
Nothing on the facts, Your Honor.
All right, Mr. Johnny Brewer, did you hear the statement that she read?
No, yes, sir.
And do you admit that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up when you enter a plea of guilty, those rights we discussed?
Yes, sir.
And what is your plea?
I plead guilty, sir.
All right, the court's going to make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty. And based upon the statement of facts and your plea, the court will make a finding of guilty. Now, it's my understanding that you are currently in prison. Are you at Madison? Where are you at?
I'm at Madison, sir.
Okay, and how long have you been, Judge Miles sent you to Madison, is that right? Claremont County?
Yeah.
How long are you in for?
I got 4 more years. I had 5.
5 years. And what offense are you in prison for?
I had my ex had a dispute, and I put my foot in the door when she went to shut the door, so I got a burglary. And then I put a pistol to my own head.
And you had what?
Then I put a gun to my head.
Okay, so you were convicted of a burglary
And
with
a
a
weapon.
firearm spec?
And a weapons under disability.
Weapons under disability. All right.
Your Honor, he also has a change of, a failure to register conviction out of Brown County. Looks like that might have been run
Concurrent.
That was concurrent.
to the burglary.
So I'm looking at, it looks like something from Judge Miles. He ran your burglary and weapons under consecutive, is that right?
Yes, sir.
Okay. All right. Ms. Nicholson, is there anything the state wants to offer before I proceed with sentencing?
Your Honor, this offense occurred prior to him going into ODRC. Obviously, the victim, the iPad was recovered, the swords were not. They did have a high sentimental value to the victim. They were gifted to him by an individual he had served in the military with, because I believe the victim had saved that individual's life. These were special swords. There are not a ton of them in existence. They are not easy to replace. We would ask for the restitution for the value of the swords as $3,165. Beyond that, it seems like he has gotten a number of breaks and that a lot of his time has been run concurrent. We would ask for at least the minimum consecutive sentence, understanding he still does have a significant, somewhat significant sentence to do, but otherwise there is essentially no punishment for this offense.
All right, anything from probation?
Nothing further.
Mr. Brewer?
Judge, so what I would say is I went to speak to Mr. Brewer on Monday, and I think the last maybe several months to a year that he's been incarcerated, number one, he's used it wisely. I think there has been a coming to the light moment in his life, and I think, he was teary-eyed when he was talking to me on Monday, and he didn't want to go through the same chain that he's been in through his life. Go to prison, get a bus pass back to the same neighborhood, get in trouble, go back, and just this complete circle. And so he asked me, obviously, I think I asked Your Honor, if he could get probation and go to a program. We wouldn't be able to accomplish that. So, but I clearly think that he's seen the light, and I'll let him elaborate about that. And he was a different individual a year ago. He's going to do the best he can for the next 4 years and come out of this and hopefully be able to turn the ship around, and that's what he wants to do. We're asking that we understand, and he apologizes to the victim, that won't be able to be replaced easily, but at the same time, he is certainly, he got a 5-year sentence, which is a long time to think about all the wrongs that he's committed. don't think the state of Ohio would be served by giving him any more time. We're asking that the time run concurrent to his current prison sentence.
All right. Mr. Johnny Brewer, anything you'd like me to know?
Yes, sir. A little bit over a year ago on the 11th, it would be a year ago, I came to the Claremont County Jail. Before then, I've been out there on methamphetamines and alcohol. It just really was a piece of trash. I mean, I just wasted my life. I threw it all away. I'm an automotive technician, made good money, had a good woman, had a good thing. I just, for some reason, derailed and went back to the narcotics. And I'd given up on life, and I had that I didn't care attitude. And along the way, when I got to the Claremont County Jail, I met a good friend. Now he's a friend of mine. His name's Dan Lohman. He does the AA in Claremont County. And at first, when I went to the classes, you know, I sat in the back and I was just mad, and I ranted about, well, why don't they give me a chance or give me a program or do this or do that? I wasn't getting it. And the man stood up one day and he said, he gave a speech. And he said he had been in and out of AA and NA and couldn't get it together, and the program didn't seem to work. But then he found out when he got serious, he actually opened the book and read it. So a light went off at that time, and I began to read the book. And as I read the book, I was like, wow, maybe there is hope. So I started trying to look more positive into my situation. And I read the big book, and I started studying, and I did other books that went with the big book. And I worked with steps. You know, he's helped me along the way, and he still helps me to the day. God bless him. And I got to the part where it said about your higher power, you know, come to believe in things. So then I found another book I needed to read. I had never read the Bible, and started reading that, attacking that. So then when I got to prison, they got talking about a therapeutic community program. They said it's 12 to 15 months. So I was like, well, what I got to lose at this point, you know? It's either keep doing this the rest of my life or apply myself. So I signed up for it, and that's where I'm at in Madison now. I do that, and I do AA and NA every week, and I go to church. I'm trying to do everything I can to turn my life around, every program. I try to volunteer and help do things. I mean, I realized what I did made victims of this person and other people in the community. They see the stuff that happens, you know. It makes other people live in fear too. What'll happen to them, you know, and their stuff. I see I see what I've done. I don't see it as I'm a victim or the system's doing me wrong. And the reason I was asking for the plea deal is because I just don't want to be returned back to the street without nowhere to go. I'd rather have somebody in my life, like probation, parole, something. If you could order that mandatory, I'd appreciate that. Because I was on it before, and that's how I had gotten my life together before. I just didn't know that. I thought I had beat the drug addiction and everything. I didn't realize that this is going to keep going if I don't actually do something about the way I'm thinking and the way I'm living. It's not just about stay out of trouble until you're off probation or parole. It's about actually changing yourself. And I didn't have a clue, but now I do, and I would like to get, when I'm released, I don't still want to go straight back to the street. I want to go somewhere like Turtle Creek or something where they can help me, you know.
You want to go there?
Or some.
Sorry.
Well, that's the only thing I know to say.
No,
you know,
I understand.
please.
I understand what you're saying. I understand the intent.
Somebody said that there's a faith-based program in Hamilton. I really want to know about it, but
Where do you live? Where's your hometown?
I grew up in Kentucky, but I've lived in and out of South Lebanon.
So you're local here to Warren County.
Yeah, I've lived in and out a lot.
Okay. Well, I got to tell you, Mr. Brewer, what you said is very well spoken, and seems to me to be sincere. And I hear, you know, dozens of these every week, And I can usually tell when someone is sincere. It's funny, because I was listening, I have a young man that I had sent to prison years ago, who went through my veterans court, and he does a podcast. And I was listening to one of his podcasts last night, and a lot of what you're saying right now, he and his guests were talking about on this podcast. It's about recovery from addiction. So you were hitting on a lot of things. You're already obviously learning things. So we'll talk about that in a minute. The reality of it is, you have 4 years left on Judge Miles' sentence. It doesn't make any sense to put you on community control right now, because you can't do it.
Can you make it mandatory I get post-release control?
No. Hang on, just hear me out. Let me finish. Okay. I've considered the statements that have been made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. I'm going to make a finding today that you are not amenable to community control, even though this is an F5. I'm going to find that it would not adequately punish you and would demean what happened in this case, and that prison is necessary to fulfill the purposes and principles of sentencing due to your extensive history and failure to respond to previous sanctions. So what I'm going to do is I'm going to order you to serve 6 months in prison, okay? I'm going to order that to be served consecutive to your current sentence, okay?
Yes.
The court will find that the consecutive sentence is necessary to punish you. It is not disproportionate to the conduct posed by you, and that your history demonstrates that a consecutive sentence is necessary to protect the public. So I'm going to make those findings today, okay? So this will be consecutive. Do we have any jail time credit?
No.
0 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions, but there is the restitution of $3,765.
$165.
How much?
$3,165.
All right, $3,165 restitution. But other than that, I'm not going to fine you. Now, you're subject to this discretionary post-release control, which I went over. Do you want me to go over that with you again?
No.
It's discretionary. That's the law. I can't make it mandatory. But I'm going to tell you something. Mr. Brewer brought this up. When you have completed your sentence for Judge Miles, I will entertain a motion for judicial release with regard to my 6 months. That's all I can do.
Okay.
So if Judge Miles lets you out early, then I will consider letting you out early. But if you finish his sentence, then file a motion for judicial release when my sentence starts, and I'll consider putting you on community control. And then we'll talk about programs, we'll talk about things. But one of the conditions is, do what you can with the time that you have now, and don't get in trouble in the institution. Okay, you got to remain infraction free. So follow the rules of the institution. Take whatever courses or whatever steps are necessary to better yourself over the next few years. Excuse me. And then I'll consider what we've just talked about.
And thank you and the prosecutor and everybody for being fair and understanding.
Okay.
And I appreciate it.
All right. Well, good luck to you, and hopefully I'll see you in a little while. Okay.
Thank you, Your Honor.
Thank you.